let's get into the Amber Heard appeal. And I saw you covered this yesterday. Let me get the document on the screen because you know how we like work off the documents. Here is the notice of appeal filed by Amber Heard's legal team. Now, first things first, there are a couple of questions that I think we need to understand. This is not the appeal. This is the notice of the appeal. So essentially, you got to tell the court, yo, we're going to appeal this. And that's essentially what this is doing. So this is putting everybody in notice we're filing an appeal. And it also gives the other side notice, too, that they have to file briefs in defense of this, because Depp's team is obviously going to file a defense to this appeal saying that everything is all good, and they're going to say everything is all bad, and then we're going to go up to the next level. So that's what this notice for. So here it is. Notice of appeal. Please take notice that defendant and counterclaim plaintiff Amber Laura Heard, pursuant to whatever rule, blah, 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 gives notice of her appeal to the Virginia Court of Appeals from this court's June 24th, 2022 final judgment. The July 13th, 2022 order on the defendant and counterclaim plaintiff's Amber Laura Heard's post-trial motion order, and from all additional orders and rulings by the trial court prior to the entry of the final judgment order and post-trial motions order. So essentially what they're saying is they're challenging everything this judge did, right? Yeah. Every order she did, everything. We're challenging it all. Every time she said overruled, we're challenging it. So they're challenging everything. Now, there's interesting because generally you can't challenge factual determinations unless it's like plainly obvious. So, there's a couple of legal arguments in here that I think that have some merit, but I don't think they're going to be successful. And there are some that are not. But essentially, that's what this notice is saying. We're challenging it all. So pursuant to the rules, blah, 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 Amber Heard certifies that the transcripts of these proceedings have been or will be, so it may not have been yet, but have been or will be filed with the clerk of the court within the time required by the rules of the Supreme Court of Virginia. Mm-hmm. And this is signed Elaine Bredehoff, blah, blah, blah. Certificate of service, so it's going everywhere. So that's essentially it. Really just a one-page document letting everybody know that we are appealing. Now, there are a couple of things that we have to talk about. First, they're trying to overturn the jury verdict, or they're trying for a new trial. Those are the two things that they are trying to get. I don't know if you'd agree with this, but I think the appeal is very close. It's going to be almost identical to the post-trial motions, right?
I would imagine so, for not the least of reasons that you have to preserve all issues on appeal.
Yeah.
And so there might be issues that are preserved that are not in the filing for the new trial, but why? So I would imagine the appeal is going to just echo, perhaps further develop in some way, the arguments we saw in the post-trial motion.
Yes.
So yeah, that would be my expectation.
So, and with those, we're talking about the Juror 15 argument, which I think is a non-starter. And I think a lot of the First Amendment issues, right? Some of her First Amendment issues was, now we've discussed this before. Amber, one of her issues is that the statements are actually true.
Yes.
Right? Now, for all of you who don't know, truth is generally an absolute defense for defamation. So if the statement is true, you really don't have any claim to defamation. Mm-hmm. But in Virginia, even if the statement is true, you can be held liable if the statement is true but gives you a false implication.
Right.
So that's
what people might not know is that New York Times versus Sullivan, which is the very famous case that dealt with public figures and raised the standard for public figures to this actual malice standard. That case also was an implied defamation case. Mm-hmm. That Sullivan himself, who was the chief of police, was not named in the article that apparently defamed him. Mm-hmm. So the fact that it was defamation by implication was not the problem. The Supreme Court didn't say in New York Times versus Sullivan, oh, you can't defame him, a public figure, because it's defamation by implication. That was not the reason. The reason was because they didn't prove actual malice. So there appears to be no federal constitutional reason. There appears to be no First Amendment reason to prohibit defamation by implication. And so then your only argument left is that it should be required as a matter of Virginia state law, which is a matter of Virginia's state law. Mm-hmm. And then you're asking the Virginia Supreme Court to decide that they're going to have a different standard or a stricter standard than the Supreme Court, which would be fine, but they don't have to. So that's the only thing you've got left.
Yes. Again, I don't think her appeal is going to be successful for the reason that you've said, and for the other stuff that we saw. It just really seems to be nonsense. One of the issues that were brought up on the post-trial motion, which I'm assuming is going to be, is that they're saying the jury verdict is inconsistent. So they're saying the
No.
jury says that she lied about the assault allegations, but Depp lied by calling them a hoax. So that's their interpretation of what happened. But when you read the judgment between what happened with Depp's judgment was saying, well, she lied about these allegations of this misconduct by Depp. But then on her end, they're saying that Depp and Waldman lied about saying that she created
Orchestrated
a crime
the
scene.
hoax
Orchestrated but specifically
in
for the
very
crime
detailed
scene.
way. That was the
Yes.
issue in Waldman's statement. It was extremely detailed. So the statements are not in conflict. When we're
No.
trying to interpret, first of all, you can in some places have mutually inconsistent verdicts. So some
Yes.
states and some jurisdictions just allow for you to have mutually inconsistent verdicts. So even in the face of a blatant conflict, a lot of courts will be like, well, oh well, too bad, so sad. The jury came to conclusions it did. The fact they're in conflict is distinctly not our problem. To the extent it is your problem, which Virginia seems to say, we can't allow for that, which again is Virginia's choice, you interpret against the conflict. So if you're looking at two verdicts, you're going to assume they're not in conflict. You're going to interpret them as not in conflict. The only way that you're going to say there's a conflict is if the conflict is unavoidable. So the question isn't, can I read these two verdicts in conflict? The question is the other way around. Can I read these two verdicts without conflict? And the answer to that is yes, it's easy. Because Waldman's statements are so specific, we can find it to be false for any number of reasons, which does not conflict with the verdict for Depp. So the idea that these statements are irreconcilably in conflict, there's no way to read them in harmony with each other, is not true. You can absolutely do it. It's not even hard. You can do it without blinking an eye.
Yeah, because
it's ridiculous.
And it's because the statement from Waldman was very specific. You orchestrated this hoax when you called the police on this particular day and messed up the house on this particular time. And the jury said you provided no evidence that was a hoax. But you did provide
there was
evidence.
Like 8 specific statements
in
that quote from Waldman. So all you have to do is find any one of them to be false, and you've got your falsity.
Yes,
and that's
so
take your pick.
But I wanted to limit it to that's different than saying all these abuse claims for the past 5 years were false. This was saying this one incident was false. And they say no, that you defamed her. That wasn't false versus the whole 5 years of stuff. So the jury, and I think it shows you that they were pretty particular. They were saying just because she lied about all that other stuff doesn't mean she lied about this.
It doesn't even require you to believe that it's false. It just has to be false in the particular way that Waldman said. I mean, on a very technical level, so that you can't even conclude the jury thought that the hoax didn't happen. They could have thought that the hoax happened, but Waldman was wrong in one of his many, many specific statements, and that was enough for them. So there's a lot of ways to read these two verdicts in harmony with each other. And again, that is our default assumption. We're going to assume they're in harmony. We're going to look for an interpretation that resolves it in harmony. And I think that's pretty easy to do.
Yeah, it's almost laughable that they're trying to pretend that it's not. So moving on from the validity of the appeal, when it comes out, we'll eventually see it. Is the next thing is that how much money this appeal is going to cost. Now, let's first talk about the transcript. 6-week trial transcript. It can range from anywhere from a couple of $30,000-$40,000 to maybe $100,000 for the transcript.
I think it's a realistic estimate.
So we're talking about just for the transcript to appeal, we got that. And that's why they said, it's not, but, is that. So you got to pay for the transcript. The second thing we're talking about paying for is the actual attorneys to do the appeal, right? You got to pay for that. And then we're talking about the bond, right? Because everybody's talking about, well, what about the bond for the appeal? So those are 3 things that Amber is going to have to do to take you to the appeal. So let's talk about the first thing, the transcripts. I'm assuming she may have enough money for the transcripts, but that's a big bill in of itself. So I'm not sure how she's going to get that, but whatever. The second thing is the insurance companies. So we have 2 insurance companies. We have Travelers Insurance Company, which are on record saying that we've spent about $8 million plus on this case already, right? And then you had New York Marine, which is also saying, well, we spent some money, but because she was found to be willfully liable, we're able to back out and not have to cover this because she intentionally did it. And I'm assuming Travelers is going to make that same argument, right? It would be stupid not to make that same argument. So with that says, do you think either Travelers or New York Marine are going to cover the course for the appeal?
It doesn't seem logical. The basis of the insurance coverage is this basis to advocate for you at the trial. And the trial is now over.
Yes.
So this is almost certainly not within the scope of that coverage. Appeals, it would be illogical for it to be. So I can't imagine they're paying for the appeal unless they think there's some basis to do so because they think there's enough probability of winning that it's in their financial interest. So it would just be a self-interested argument, but I don't think there is enough for them to win. So I wouldn't be paying for the appeal if I were them.
And what do you think about, because I'm assuming, based on their insurance coverage, like they could have insurance coverage that says yes, you pay it all the way through.
Sure.
And if that's the case, what do you think about the argument that already have been made that they don't have to cover this particular case because she's been found willfully liable?
No, well, that doesn't work. If they have insurance coverage all the way through, then the finding of the willfulness is obviously a finding that's appealable. The jury could be theoretically wrong. So if we have a duty to appeal, then the fact the jury found that, it's like, well, let's challenge the jury's finding.
It's going to be interesting because I think the way New York Marine kind of put it was that as soon as the jury found that, we're done, right? Now, if she can appeal, and if it overturns it, then we probably have enough. But, we don't have to put up the money because we have this jury verdict. So, but we'll see.
I think they're done because I think any insurance coverage she had only pertained to the trial and not appeal, which is perfectly logical.
And that makes sense. So now we've done with Travelers. So now let's talk about the bond. Now, I know there's a lot of lawyers talking about the bond. So let me just go over the process. So the process is, let's say I want to appeal in Virginia. Now, this is from what Rob is saying and from what I've been reading. In Virginia, if you want to appeal, you do the notice of the appeal. Now, you pay a $500, there's like a $500 fee you have to pay. But this is the part where the bond comes in. So the bond is known as a suspension bond. Now, suspension bond is suspension of execution of the judgment. So what that means is that since Depp has won, Depp can now go and say, I want my money from Amber Heard, right? I've won. He is, and I want this judgment to be executed. I want her house. I want a car. I want to do whatever to get my money. But now Amber's saying, well, hold on. I thought that was wrong. So I want to appeal. So Virginia says, okay, let's do this. If you want to appeal, you have that right. You can appeal. If you want to suspend execution of the judgment, meaning that he can't take your stuff, you then have to put up the judgment amount in a bond and 6% per year. That's what the judge said. But if you don't, right, if you don't have that, or if you don't want to put that money up, you can still appeal, but that doesn't stop. The fact that you're appealing doesn't stop that person from collecting on that judgment. So that's now the issue now, is that does the insurance company put that money up? So he doesn't collect, because if they put it up and they lose, then they're out of that money. Does Amber put that money up? Do you say, all right, I'm not going to put money up and play broke? And now, so it was interesting because listening to some of the coverage of this, some people were saying that that's the reason why she was at Target, and who was she at? She was at like a TJ Maxx shopping to kind of show that she has no money. She can't pay. She can't put up a $10 million bond to try to make that argument that, hey, even if, he can't collect because I'm shopping at TJ Maxx, that type of thing. So
I'll take your TJ Maxx money too. I'm just saying.
So at the end of the day, just understand, people, in this process, Amber can put that 10.35 million, 6% up. I think it's unlikely unless the insurance company is going to put that up. I think it's unlikely.
The insurance company will never do it because they don't think they have liability, because their whole argument is the willfulness. So we're not liable. So why would they put the money up?
Yeah.
But not for the least reasons. Also, I don't think her insurance caps cover that amount, at least in terms of the New York Marine. It was like $1 million out.
Yeah.
So the most that they would be theoretically required to pay in any event is $1 million. So they're not going to put up a $10 million bond because their liability is in $10 million. I haven't read the Travelers insurance, but yeah.
The Travelers
so she's
already
not
paid
going to put the
$8
money
though,
up.
so Yeah, but
So,
Travelers already paid 8, so I'm not sure what their coverage is, but they're in it for a lot.
yeah.
But I
Apparently,
definitely agree.
Travelers is the best insurance company ever. Who knew?
They're paying for you. They're paying for everything, right? But now, at the end of the day, that is the appeal issue. So
Hmm.
just as a quick recap, Amber has put the notice of appeal. She hasn't actually put the appeal in yet. Who's paying for the appeal? We still got questions of that. Or will insurance companies cover it? We answered that question, and just the process of the suspension bond. And I don't believe Amber's going to put up the 10.35 million plus 6% interest for the suspension bond. But now, last thing is that JD's team said they're not going to go after the money. So technically, if they don't execute the judgment, she's still in the same place, right? Because putting up the money is to prevent him from executing the judgment. So if Johnny and his team is saying we're not going to execute the judgment, then it doesn't matter
They
anyway.
should totally
right?
execute the judgment. They're too soft.
Yeah, I would do it too. No joke. I want my money. That's what I'd be telling Amber. I don't care what you do. I want my money. And then I'll play bankruptcy if she wins the appeal. All right, last
She
question.
can't bankrupt her way out of that too because it's
No.
willfulness. Bankruptcy doesn't even work.
No,
She
what I'm
owes me that
saying
money no matter what happens.
But I'm saying Johnny Depp, he spends all the money. Like after he gets the $10 million, he spends it all and says, I don't have any money. I can't pay you back. And then she has to sue him for the money back. Last question. Now, this is, I think, 3D chess. But I got to ask, she's appealed, right? So Amber Heard is notice of appeal, and eventually, if she does appeal. My issue is, I think it's almost forcing Depp to appeal her $2 million verdict.
Sure.
Because if she wins her appeal, and even if she just gets it sent back to the trial court, Depp is still on the hook for $2 million.
Right.
And if he doesn't appeal within a certain amount of time, he loses that right. He waives his right to an appeal.
Correct.
So now, if you were Depp's team, would you appeal her $2 million verdict?
Of course, I would. I fortunately don't have to file that for some time under the rules.
Yeah.
She has to first file her brief, which isn't due for, I think, 40 days or something like that. And then I have to, at some point in that, file a response, which can include my counter appeal. So I don't have to file my appeal basically for another 2 months or something if I'm Depp. But why not? I think that the legal grounds to attack Amber Heard's claims are much better.
Yes.
In terms of, there seems to be law that seems to strongly suggest that the claim is invalid. Amber Heard wants to invent new law out of nothing. Well, that's not 100% correct. There's law in other jurisdictions, just not in Virginia. So she wants this to be a novel question of law in Virginia. So there's no Virginia law specifically that is allowing her to do what she wants to do, but she wants to create new law. Okay, you can do that. That's what appellate courts are for. But there does seem to be law that says that the judgment that Amber Heard has is invalid, for not the least of reasons that Waldman can't legally be an agent because he's an independent contractor. In order to be an agent, you have to be an employee, and he's not. So he can't therefore, you can't therefore get to Johnny Depp because you don't have the agency. Mm-hmm. And also on top of that, where the scope of the agency is too speculative, and there are some other reasons on top of that. So I think his odds on appeal are very good comparatively. So I of course would file. Why wouldn't I? It's a reasonably easy argument, all things considered, and I lose nothing by doing it. And
that's true.
It's a little paint by numbers actually, because I already have established law. So unlike Amber Heard, where I have to invent something out of nothing, it's just like, well, the Supreme Court of Virginia has already said this, so we should go do that. So it's an easier argument.
Yeah, I'd agree. If I had to be an attorney for a winning side, I would definitely choose Depp's argument, because I think Depp has the better. I agree with you 100%. I think Depp has the better argument in terms of attaching Waldman statements to him. Yeah, I think it's just such a better argument.